Hi, everyone. Apologies here, getting to the right slide. Thank you. Welcome to the webinar. For this webinar, it is Estate Planning, Leaving a Legacy. Hello, my name is Cooley. I am the Director of Targeted Outreach at the California Department of Financial Protection and Innovation, also known as the DFPI. You know, it's right at 12. I want to give everyone a chance to get logged in before we jump into the webinar. It's a lot of really great content. As you got a really brief viewing of it. So let's go ahead and just give everyone what I got here. Let's give everyone another minute to join in before we get started. Okay. Thank you for joining. We'll be right back. Okay, everyone. Thank you for joining. Thank you for your patience. Again, my name is Cooley. I'm the Targeted Outreach Director for the California Department of Financial Protection Innovation, also known as the DFPI. For today's webinar, it's on estate planning, leaving a legacy. It's going to be a great, fantastic webinar. Let's go ahead and get started. So a little bit of disclaimer, this is a big disclaimer, but very important. Your cameras and microphones have been turned off for the Zoom meeting. Please use Zoom's Q&A feature if you want to submit your questions to us. We have a dedicated time at the very end of the webinar, and we will be answering your questions. The views and opinions expressed in this presentation are those of the presenters. They do not necessarily reflect those of the DFPI. Any mentions of specific products, services, or brands in this presentation is for informational purposes only and is not an endorsement or a recommendation. This presentation is for educational and informational purposes only. This is not legal or financial advice and does not replace any independent or professional judgment. We're a big proponent of doing your own research. And by being here, that's what you're doing. So thank you. The DFPI appreciates the assistance and expertise of our guest speaker, but we do not endorse them. So she is here, and we're very thankful for having her here to help us do the presentation. But this is not any kind of endorsement of her or her services. Please do your own research before seeking out any estate planner or attorney for assistance. For more information, or if you do have questions about this webinar or any other questions about the things that we do, please send an email to us. Our email is outreach@dfpi.ca.gov. All right, let's jump right in. So just quickly, I want to plug the department. Who is the DFPI? What do we do? Well, we are the California's financial regulator. The state of California's financial regulator. We help maintain a fair, healthy, and trusted financial marketplace for all Californians. Our department does this through regulating and enforcing a variety of financial services, products, and professionals. There's a whole list of them, things like banks, state chartered banks, credit unions, payday lenders, student loan servicers, mortgage lenders, investment broker or dealer advisors. So if you have any issues with those licensees of ours, feel free to submit a complaint to us and we will help mediate that. And of course, we provide free presentations throughout the state of California, just like this, to help protect consumers, to help inform them, and to help prevent them from falling prey to frauds and scams. If you want to learn more, we have a web page dedicated for consumers. It's dfpi.ca.gov/consumers. Okay, with that, I am very honored and pleased to welcome Yvette Kuyate, who is an attorney, um, who's going to be helping, by the way, helping with this webinar. She's a founding partner of Kuyate Law Group in San Diego. She's a former prosecutor and experienced litigator and financial literacy advocate. She dedicates one day a month to providing free legal counsel to victims of abuse at the One Safe Place Family Justice Center in San Marcos. She is passionate about empowering others to grow and preserve their wealth with over 100 keynote and webinar presentations. She's been featured on television, radio, and has been selected by the San Diego Business Journal's Women of Influence of Law, San Diego Business Journal's Women of Influence of Law honoree for the last 2 years. That's a lot to say. So with that, I am pleased to welcome Yvette. Thank you for joining us. It is your webinar, and please take it.
Thank you so much, Q. That was a beautiful intro. How are you? Thank you. Thanks for your team, but especially thanks to DFPI for putting this on. This is such crucial information. We got a lot to cover. So as Q said, after there will be an opportunity for Q&A, and there will also be an opportunity for you to forward your questions directly into the outreach email for DFPI. So with that being said, let's go ahead and get started. If we can start queuing up the next slide. So let's get into it. I'm sure you've heard one or more of these terms when it comes to estate planning. We've heard that term, those terms: probate, will, executor, advance healthcare directive. It can get really confusing, and most people, it's not that they don't know this is important. It's just a lot of people don't know where to start. So hopefully the goal from today is going to be kind of getting you guys to a place where you understand the nuts and bolts, what goes into an estate plan, what's important, why it's important, and so that you have a good solid basis of working knowledge. So next slide. All right. So I like to ask, when I talk about this, I like to bring up different scenarios that most people might not necessarily think of when we think of estate planning. It's not just for planning for your death. It's actually planning for your family, your assets, for your life, and for your potential disability. So one thing that most people don't think about is, what about my assets? What about protection from lawsuits? Those of us that have children that are out of the home, so they don't start being your baby when they leave the home, but there are certain things that the law says now that they need a HIPAA release form for you to, if there is an emergency while they're at college or whatever, for you to actually be able to speak to doctors. We live in a digital world. So what about the intangibles of things like airline miles, right? Or Facebook, or different types of accounts that we might have in a digital world. We're getting into a world where cryptocurrency and those sort of things these are all parts of your life, your assets, your estate, and obviously planning for retirement and beyond. So it's a topic that encompasses a lot. I'm going to touch on all of these, but I want you to just go beyond. If you can take what you think you know about it and broaden it to, wow, this actually is a topic that encompasses a lot of other things that maybe I had not thought of. All right, next slide. Okay, so nuts and bolts, right? There within estate planning, we are going to talk about trusts, wills. We're going to talk about life insurance. We're going to briefly talk about business succession plans for those that have businesses. We're going to talk about charitable donations that you can make within your planning. And ultimately, it's who gets what, right? That's the property distribution. If I'm disabled or if I die, what's going to happen with my assets? All right. So first, let's get rid of some common misconceptions that are the most common ones that I get from time to time, right? And so, no, it's not just for the rich and wealthy. Everybody needs a plan. Okay. It is for everybody to think about because we're all headed down the end of life stage. So it's something that we all should think about. Um, hey, Yvette, I did it. I have it. It's one and done. Well, let me say this. Estate planning is like having a vehicle. You want to make sure that when you get in the car and drive it, it's going to work. Your documents, your assets are going to go where you want them to go. The horrible time to find out that your plan's not working is when something happens. So it's like a car, you got to keep it maintained. It's not a one and done. Hopefully you have a relationship with people that have drafted yours previously because laws change and families change all the time. So what your life looks like right now might look like 20 years from now and vice versa. When you did it in the 80s, life can look totally different. So it actually is something that should be updated continuously. Um, this is a great common one I get too is I have a will, I'm good. So we'll talk about that and then you can answer that for yourself. I can do it myself. We live in a world where you can get a lot of information on the internet. And, I'll tell you, my dad taught me how to change a car tire and change oil. He said, if I don't teach you those two things before you go to college, I failed you as a father. Well, just because I know how to do it doesn't mean I should, right? Just because I have the tools to do it doesn't mean I should. There is actually, it's a very complex area of law. And you really want to make sure that you don't leave this to chance. So yes, you could do it on your own, but should you? Probably not. You want to at least get your documents reviewed by a professional if you've gone ahead and done one of those online sort of programs. Okay. And then this one too. Well, when I go, it's all going to go to my spouse, and that might work for some families, but there are some families where there's other issues that come into play, and we'll talk about that. And so leaving it necessarily to your spouse at the end of the day might not be what you want. You may have a blended family on either end. There may be concerns about finances and that spouse's ability to handle assets, lawsuits, right? There's different things that come into play that maybe that wouldn't be the best thing for you. Okay. So let's talk about the big elephant in the room. Okay. What is probate? Because I'm going to launch from here because I really want you to have an understanding of probate court. All right. So probate court is the process of administering your estate. So what does that mean? We have in California and throughout our country, we have different types of courts. We have civil court, family court, criminal court, bankruptcy court, immigration court, you name it, right? Probate is specifically designed to administer estates. And so when somebody dies, if they have a will or if they don't have a will, the judge has to administer that person's estate according to probate procedures. And so that's what it looks like. That's what we're going to be talking a lot about today. Why that might not be a good thing for your family and how to avoid it. Okay. So take a note of this. Every estate, I don't care if you're 18 or 88, it doesn't matter. These are the 4 musts that you have to have, regardless of how big your assets are. I don't care if you have $8 in the bank or you got 80,000. It doesn't matter. There are 4 documents, 4 basic components of a plan that you need to have in place. So the first one is, yes, it's a will. And for those of you that have minor children, this is crucial because the will is where you're going to name who would get custody of your children's person and also your children's estate that you would leave your children should something happen to you. So a will is much more than just a set of instructions. A will, for those of us that have parents, It goes beyond that. We're talking about protecting our children. Um, what happens when we don't have a will? We'll get into that. The second document is a financial power of attorney. This is crucial. Again, we're planning for disability, not just death. We're planning for life, right? So what happens if I go out, get in a car accident, and now I'm in the hospital for 5, 6 months? Or what if I get long-term COVID? What if I get dementia, Alzheimer's, something like that? I need to designate somebody that can take control of my day-to-day affairs, somebody that I trust that would be able to step in and act when I cannot act for my finances and my day-to-day things. For those of you that have businesses, this is crucial because you need to make sure that that person or another person can make sure that your business continue day-to-day operations in the event that you cannot. Whether it's you're traveling or you're injured or you're sick, your day-to-day operations need to continue running. So this piece is very crucial. Okay, third document, Advanced Healthcare Directive. Sometimes called a living will in other states like Virginia. Advanced Healthcare Directive that we call here in California, that is similar to the financial one, only that this power of attorney is naming and designating your agent to make medical decisions for you. So that could be as simple as I'm going in for a routine surgical procedure, or something more long-term where I am diagnosed with a deteriorating mental condition, dementia, Alzheimer's, something like that. So this is very crucial for those of us that have parents or aging parents, and we know that they may be around the corner to needing our help coming in more and more. This would allow and avoid having to go to probate court to open a petition for conservatorship over that person because they're no longer able to manage their day-to-day affairs or their medical decisions. So both of these documents, having them well in advance, knowing if something happens, not when I die, but in between that, if something happens to me, somebody can step in. The Advanced Healthcare Directive is also crucial because it lets your family members know what are your last wishes. So nobody's left to guess what would grandma or mom, what would she have wanted, life support, organ donation, et cetera, et cetera. There's a lot of turmoil with families that are dealing with members that are sick. And the last thing that we want to do is put them in a situation where there's disagreements on what you would have wanted. So this document avoids that. It lays it all out and makes sure that they know exactly what your preferences are so that they could be honored. Okay. And then the last document goes in parallel with that one, but it is the HIPAA release, Health Insurance Portability and Accountability. You heard it as HIPAA when you go to the doctor's office. So it allows your agent for your medical directive to get access to your medical information that they might need in order to make these medical decisions. And I talked about this in the beginning. Those of us with college students or young adults that aren't quite fully adulted yet, right? They might still need some help getting, through some of the medical red tape, making doctor's appointments, things like that. This, having that in place before they go to college, would be something that parents would want to think about so that their students, God forbid, something happens when they're away, they can actually get on the phone quickly and help their child navigate healthcare while they're away from home. All right, so those are the 4 documents, 4 essentials, regardless of age or social economic status. Everybody needs these. Next slide. Okay, the most common question that I get, should I have a will or should I have a trust? Well, let's go through the pros and cons, and then you're going to answer this for yourself. All right. What is a will? All right. Basic. What's a will? A will is a set of instructions for that probate judge to decide their validity and administer your estate according to your wishes. When somebody dies without a will, the probate code speaks on your behalf. So thankfully, we live in a country where we have rules and regulations and laws and legislatures in place That would be the probate court deciding based on the code if you don't have a will, if you die intestate. If you have a will, now it's a little better. It's your wishes versus the probate code. But in both scenarios, you still have to go before a probate judge. Okay, so what are some pros and some cons? Pros are they're a little bit easier to complete, they're less expensive, easier to administer, unless you have a litigation in probate court. And the pros is this is where you're going to name the legal guardians for your children. The cons, well, again, we're subject to probate court. It is public knowledge. Anything in court is open and public record. So that means that once that happens, it could be challenged by family, heirs, creditors, whoever wants to come into the probate proceedings and make a claim against your estate. If that happens, it is time consuming, it's expensive, and it can be very challenging to wrap up. So what is a will? There you have it, set of instructions. Next slide. Let's contrast a will with a trust. What is a trust? So I'm going to talk here specifically about the most common type of trust that most people have or want that will work for them. And that's a revocable living trust, revocable family trust. Revocable meaning, think of it theoretically as I have this safe deposit box. I'm transferring the assets into that box during my lifetime. I originated, I'm the grantor, I'm also the trustee, meaning during my life, I can make changes to it. I have the keys. I can put stuff in, take stuff out, put people in, put people out. And then when I pass, I give that set of keys to my successor trustee. So what does a successor trustee do? The successor trustee, when I die and give them the keys, it is now their job to administer my estate according to my directions within my trust. The key here is that because the transfer of your assets are done during your lifetime, we're eliminating the need for a probate court to set an order to get those assets transferred. So no order is needed, therefore no judge is needed. The trustee has the single power to go ahead and administer it according to your wishes. So you guessed it, pros here. One of my favorites, we're not subject to probate. There's huge tax savings potential for your heirs. We can get into some pretty sophisticated planning. Of course, there's less heartaches because we're out of the public eye. You can assign professional companies to do this. If you don't trust your family, or if you think that there's going to be fighting, or you have a sizable estate, you can assign a professional trustee. It's much more quicker to administer and settle than having to litigate anything in probate court. And you have full autonomy and discretion over what can happen. The best thing is, like I mentioned before, life looks different when seasons change. So if in 20 years life looks different, you can still go in, make the changes, and keep this updated according to your preferences. Con, it is more expensive, it's more time consuming, and because you are doing the transfers into it during your lifetime, it is one thing that you need to keep it updated, and you need to make sure that it is funded correctly. When people talk about funding the trust, it means we're retitling the assets to that trust. So for example, it would be Yvette's home now into my trust would be Yvette's home as Yvette as trustee of the whatever family trust. So it's still my asset. I'm not getting rid of it for ownership reasons, but the transfer is done in my lifetime to my trust. That's what people mean when they say funding and retitling. Okay, next slide. So let me put the question back on you. So here it is. Which one do I need? Well, I think the question really is, do I want my family to go to probate court when I die? I've given you the three options. One is not doing anything, dying intestate, which I never recommend because nobody wants the government making the decisions for them. So that's the red door, do not enter. Blue door is, well, I have a will, and it's better than the government deciding for me. It is my wishes. But again, weigh your options. Best scenario is I have a trust, and now we're out of probate court, we're out of the public eye, and it's done in a way that I know my family's not going to have to mourn me and deal with court at the same time. Next slide. Better visual. I know some of you are visual, so here's a good visual representation. I have a will. I don't have a will. Either way, that is your golden ticket before the judge. Okay. I have a trust. We're avoiding probate. We're going down the other route where everything is more protected and private. There you have it. Okay, next slide. All right, next slide. So I want to be a little bit, let me go deeper into how much probate does it how much does it actually cost to go through probate? So a lot of people don't think about, okay, well, I own a home or I don't own a home, but hey, maybe it's something my family can afford it. And maybe they could. But think about the expenses. So you see this slide here. In interest of time, I'm not going to go over the whole slide, but we're the probate court section 10800 sets attorney's fees. So this is an area where the attorneys are going to be paid depending on the value of the estate. So there's money to open the probate proceeding. There's money that the attorneys are going to be entitled to depending on the value of your estate. Right now, most homes in California are above $500,000. So we're already probably in the $3,000 to $16,000 attorney's fees squares at the bottom that you're seeing. And that's not counting for litigation, if any fighting occurs or any extraordinary fees that might need to be taken care of, like liens or selling the estate, anything like that that would entitle more fees from your estate to be paid. There may be a probate referee that needs to be assigned, a bond that needs to be paid, and then at the end, a final petition. So you're looking at least $24,000 in attorney's fees for a basic, I would say $500,000 estate in the state of California. It's quite expensive, way, way more than you would expect to pay for having a trust built up front. Okay, next slide. And just to compare, because I get this question a lot, yes, California does have a small estate affidavit if your estate is less than 150,000 to avoid probate. But other states, look at New Hampshire and Georgia, look at Virginia. And if you own anything over $1, or anything over $50,000, that's a Tesla. You're looking at guaranteed ticket to probate court. So just to kind of give you a perspective of where our state lies compared to some other states in the country. Okay, next slide. Okay, for those of you that we're back into, why a trust might be better for your specific situation. So I mentioned to you that probate court equals public information. And for my folks that are that serve the public, law enforcement, correction officers, maybe teachers, therapists, doctors, lawyers, depending on your field. This is a big reason why we would not want to take the chance and have our information, our heirs, our property as a matter of public record. As Q pointed out, I'm a former prosecutor. And I wouldn't want somebody that I put in jail knowing who my kids are, where my assets are, because unfortunately, we live in this type of world. So this is another reason that I want those of you in these professions or have people in these professions to think about, it's not that I can afford it, is do I really want that possibility of having my stuff out in public record. Okay. All right. Here's another reason. Okay. So, I'm a mom of girls. I have daughters. And ideally, I'm hoping that we are blessed with son-in-laws that are wonderful, but we never know. What if we get one of these other guys' options on the left or the right, right? So with a trust, there are certain sub-trusts that you can build out for preparing your children as they're older, or maybe if they're already married. There are certain exclusions that you can put in to exclude their spouses or ex-spouses, future spouses or future ex-spouses from being decision makers, from being trustees or co-trustees with them in their trust. If you decided to set out that sort of sub-trust for your children. I've also seen it where parents have left a trust, and in the case of divorces, this has been tried to be being used against them for a claim of alimony and support. And so while we can't ensure, we don't know what our children are going to do, but we can try to put the best bumper rails that we can against life, because we don't know what's going to happen with life. And so this protects them a little bit more in the event that they do get married and that's not a great marriage, or that's not a great spouse. As my husband says, we're working to leave something for our kids, not for their spouses. So just something to consider for those of you that have children, in the future. Okay. Really quickly, I want to talk about different types of scenarios. There is no one size fits all. And their families, this is one reason that estate planning is so complex. It's a complex field. There's a lot of different needs within families, sometimes more than one of what I'm about to talk about, right? But I want to talk about families with disabled children, maybe children either that are receiving SSI or a disability, or they're on the spectrum, or maybe beyond that, medically fragile children. So having a special needs trust for that child is going to be crucial. So most of the planning that I do we're planning for children to leave. We're planning for children one day they're going to leave the home, get married, as I just talked about. These families are near and dear to my heart, because these families, they're not planning for the child to leave. They have to plan indefinitely for that child to be relying on them. And then when they pass, somebody else that child perhaps is going to have to rely on when they pass. So that's one consideration. Another consideration is, what happens if I leave my bank account to my child that is receiving SSI? Well, what's going to happen is that I'm going to potentially, by doing that, and I mean well, it's going to potentially knock off my child from eligibility of these disability programs, because they're going to have to report it. The government's going to say, that's great, you have this inheritance, go ahead and use that, and then come back and reapply. That could be devastating for a family with medically fragile children or disabled individuals. It is so hard to get the eligibility. So the way to do that is that we leave them an inheritance in a special needs trust that someone is going to manage, so that the money does not flow directly into their hand, therefore not compromising their eligibility for benefits, and ensuring that they could still be a beneficiary. These are very specific. They have to have very specific wordings, and they have to be treated very, very cautiously. So that's one scenario that I want to bring up to families with special needs. We need a special needs trust built out. This is in addition to your regular family trust. These are trusts that are specific for that heir. Okay. What about single parents? As Q pointed out, I do a lot of work with survivors of violence and abuse. And sometimes it's not going to be appropriate for that child to, if something happened to mom or dad, to go to the perpetrator or to the abuser because the first parent has died or passed on. So these require a very specific planning strategy, and it can be a little bit complex, but it can be done. Um, what about blended families? Blended families have their own type of consideration. There's mine, yours, and ours, right? But in addition to that, there's also other parents that would potentially come in and be involved or not be involved. Um, Adult children or minor children. There's a lot, and families with blended family issues are near and dear to my heart. We're a blended family, so I get it. But this one should be taken very, very approach very direct and very cautiously too, because this could have a lot of loopholes where or blind spots that people might not think of. So it's important to special consideration for blended families. Okay. And then lastly, my folks in the sandwich generation, right? What I mean by that is maybe you're millennial or Gen Z and you have adult parents that are living with you or you're taking care of, but you also have children that you're raising or that have come back home. So you're in that sandwich generation where we're trying to put the mask on you, but we're also trying to plan for them. So these families are multi-generational planning. There are issues across the three spectrums that we get into to plan. Those with older folks, we need to plan for potential inheritances that they might leave behind, because that can affect the taxes that you pay as an heir. So we can talk about that in a minute. I just want to quickly just bring up these special circumstances when it comes to estate planning. Okay, next slide. All right, let's talk about lawsuits quickly. We're going to switch gears here because I get this question a lot, and I want to be very clear. Having your home in a revocable trust does not provide you asset protection. It does not, right? I'll say that again. Having your home in revocable trust does not provide you asset protection because it is not taking the ownership out of your name. It is still your asset. However, when it comes to lawsuits, there is a thing called the California homestead exemption that you can file, and it would allow you a buffer on any judgments against you and your home up until certain limits. And those limits change every year. You have the current limits on your screen. This is probably a whole other webinar in and of itself, but just I want to be clear that it is not asset protection in and of itself. You do have this California homestead exemption. There are other things that we could do as far as asset protection goes, but that's probably for another webinar. Okay, next slide. Okay. Briefly, I get this question a lot, like what actually goes into my trust? So as I mentioned, what's in the cookie jar, right? What's into my safe deposit box? And so your assets, your home, your liquid assets, anything that is sizable that you're not touching, not your day-to-day accounts, life insurance, 401ks, those cannot be retitled to your trust because those are specific to you, your service credits, or you as the life insurance owner. But what we do is we have those funds cycle through the trust so that the trust is the beneficiary. And then your trustee can administer those benefits. They can actually elongate them, take advantage of the CARES Act that was recently passed so that your beneficiaries can take out and payments rather than a lump sum and potentially change their tax bracket. But again, just in a quick nutshell, these are some things to keep in mind when it comes to funding, putting things in the cookie jar, and then, yeah, protecting ourselves from lawsuits. Next slide. The family home. Okay. So for a lot of my clients, the main asset is the family home. So I want to talk briefly about how the Medicare Recovery Act impacts or could potentially impact leaving the family home to your heirs. So next slide. Oh, and capital gains tax too. I forgot about this one. Thanks. So capital gains. So let's go back. So capital gains, what is it, and what is it, how does a trust benefit me in this matter? So let's say that my dad leaves me his ranch, and it's a 10-acre ranch. He bought it after he came back from Vietnam, and he bought it for like, I don't know, 100,000. Now that ranch has appreciated in value to over $1 million. If he were to transfer that to me now without a trust, then I would potentially be on the hook for capital that increase, that capital gains tax that I would have to pay when I sell the ranch. Now, if he transfers it to me in trust, then I get the step up in basis to the ranch as of the date that he died, as of the date that I get the ranch, because I stepped up into his shoes. And I'm just paying the difference between the date of death to the date of being it sold, rather than in the 70s when he bought it all the way to now. So that's a crucial tax benefit for your heirs when you're thinking about leaving property, leaving the family home. That's how capital gains taxes work. And it's not limited to homes. It could be also stocks and things like that. Put it in a trust, make sure your heirs inherit it from the trust and not directly in their hand. Yeah, next slide. Okay. So as I was saying, the Medicare Recovery Act, how does that affect people? How can it affect people? I'm going to go through this quickly because this could be a whole presentation of itself, but I like to make sure that people understand this. So when people end up on California Medicaid, there is, next slide, there is a Medicare Recovery Act where if they don't have long-term insurance for potential, like say, nursing home costs, the state can recoup from the estate, mainly the house. They could potentially recoup based on the federal regulations that are now into our California law. And so what ways to avoid that? Okay, well, we have a couple options. We need to plan well in advance. This would look like potentially establishing an irrevocable trust. This is now we're getting into Medicare asset protection planning. But whereas before we've been talking about revocable trusts, these are still in my ownership. An irrevocable trust would put the home in somebody else's name. It's no longer my asset. This has to be done very quickly. There are look back policies and periods that we need to be in compliance with. But I want to flag this because I get this question a lot with my older folks. Okay, next slide. Life insurance, we talked about this too, but I want to go deeper into life insurance because this plays a crucial puzzle piece into this whole Recovery Act. Life insurance policies nowadays have this rider that's called long-term care components to them. And so what that does is a life insurance on your money and your health. So if you become chronically disabled and you need nursing home care, and I'm not just talking about elderly with dementia, Alzheimer's, this could be somebody, a young person that a long-term accident or arthritis, rheumatoid arthritis, a chronic anything. These long-term care would kick in and they would help pay for these daily living expenses, if we can see that on the next slide. Okay. So that you're not having to tap into your savings and you're not having to apply for Medicaid, potentially having to put your assets into the bowling ball lane of the Medicaid recovery program. It protects you from having to go down those routes. Sorry. So this is something that you should be, taking into account with a seasoned financial professional, with your estate planning attorney, to make sure that you are tying or closing up that potential doorway for down the road. Okay. Next slide. I don't know about you, but nowadays, I mean, not a lot of people have extra income. So the thought of paying $375 a day or over $100,000 a month for a family member to be in a nursing home, people just don't have that kind of money. We're people are hurting. So this is the reality. You know, it is very, very expensive. Um, and I've seen people have to do this. It's not a good plan. So we need to really plan ahead. Again, I'm talking to my sandwich generation. You need to put that mask on yourself, and you need to plan ahead with mom, dad, grandma, grandpa. You know, how are we going to actually accomplish this if that day comes? What's it going to look like? And don't do it when the nursing home staff come to the door. We need to plan well in advance. Again, there's look back laws and regulations that we need to be cognizant of. So this definitely is a specific type of planning that you need a professional for. All right. And lastly, I'll just leave you with this. My goal, as Q pointed out, is I want to make sure that we're going beyond just the beautiful documents, right? Anybody can put together a binder and hand you documents. You've got those four things that I mentioned, the four basic documents. Maybe you did a trust, maybe you didn't, but I need it to work. Otherwise, I feel like I failed you as an estate planning lawyer because I need it to work. And what do I mean by that? That means that I need those documents to work for you when you hit retirement, when you potentially go into long-term care. I need those to work for your heirs so that they have something left behind, so that we're not in probate court, having to pay exuberant amount of attorney's fees and court costs. I need it to work so that you're not having to dip into your savings to pay for medical bills that you could have planned for and prepared for well in advance. So again, you're not into that bowling ball lane of the Medicare asset recovery. So will it work? Let's make sure that you have enough savings, that you have, you're not just counting on Social Security. You have reliable income. You are doing things well in advance. You're taking advantage of time and putting them in vehicles that are growing your money so that you are able to make it work. And you're also able to update it as the seasons change with your life. So that's my goal. I would recommend that any estate planning attorney that you go to has this like holistic sort of view. Again, because it's beyond just what's in the documents. It's that analogy of a car. We want it to turn on and go where you want it to when you need it to. Okay. And lastly, yeah, we've all heard these growing up, right? Pinch your pennies, save for a rainy day. We can't afford it. Money doesn't grow on trees. When it comes to your estate plan, we just need to revisit maybe some of those old money beliefs that we thought of or we grew up with, and we need to discard them. And we need to think of this as an investment for myself, for my family, for not just my death, for my disability, for my life that I need to take care of. Thank you, Ku. Back to you.
Okay, awesome, Yvette. A lot of really fantastic information. I was watching the Q&A. We're getting a ton of questions. So with that, I would say if you do have any questions, I know there's a lot, feel free to email my team at outreach@dfpi.ca.gov. We will forward your questions to Yvette, and she can help you as much as she can. All right, let's jump right into our Q&A session. Again, just a reminder, if you do have questions, comments, please put in the Zoom's Q&A feature. I don't know if we're going to be able to get to all the questions. Some of the questions are a little specific and they have, I want to say, it's going to take too long to answer, but we will try to answer all the questions, especially if we take them offline. I'm going to hit some of the more general questions first. So let's start this one. Can a non-citizen or non-resident be a successor trustee? All my possible successor trustees are in another country.
Yeah, it's a really good question. We need to be very careful to not enter international trust waters. And so what I'll generally recommend in a situation like this is to have a co-trustee acting with your agent that is abroad, if possible, uh, or have specific provisions that we don't have time to go into today, to keep us out of the government deeming that an international trust. We don't want that. So that is a very, very specific niche. But good, thanks for asking.
Yeah, that's a great question. And by the way, I don't know anything here. So, Yvette, if you think the question is going to take too long to answer, because there is a lot of nuance, as you've mentioned before, a lot of this, there's a lot of details involved. So, feel free to say, hey, let's just take the answer offline um, before you answer them. So, here's another one. I have a trust. How can I check whether it is properly titled? I'm assuming everything they put into the trust is titled correctly.
Yeah. The main thing you want to, if there's a home, you want to make sure that you pull the current deed and that the trust is listed on the current deed of your home. You can do that by going to the county assessor's office in whatever county you live in. Other than that, you can go specifically to every bank, every entity that you have. You need to do that. That's not something that attorneys generally will do that. But you you should go back to whoever drafted your stuff and make sure that you follow their instructions on how to properly retitle everything.
Great question. Thank you. Here's one. It might be a little too specific. There might be some nuance here. If I leave my house on the will to my child, but it is a joint tenancy deed, we didn't talk about that. How does it work?
So this one might need to be offline because a lot of people get joint tenancy confused. But essentially, if depending on how you have ownership with another person, you're generally only able to leave your part, uh, not their part. And so how it would work would be you all need to be in agreement as to the ultimate outcome.
Great. Thank you. So, yeah, there's a lot of, we've got to talk about joint tenancy and all that. So, yeah, good point there. Is there a standard HIPAA release form for California?
There's standard HIPAA laws. I think that's what the question is asking. HIPAA is a federal mandate, so we need to make sure that we're in compliance with that as to a specific form. I would say no. Every hospital probably has its own variation of HIPAA, but the standard is our federal laws.
Okay. This one might be too specific. Hold on a second. Is a trust or will better for a single person whose husband has passed away and there are no children? This might be very situational.
Yeah. Again, I would ask, go kind of think back on who are my heirs going to be? What am I going to leave behind? And regardless of what's happened, do I want them to potentially go to probate court? So that's really going to be an individual um, decision.
Does life insurance proceeds go to probate if there is beneficiaries named?
I'm going to give you this attorney answer. Maybe I don't know enough about this scenario, but I will say this. Please never, never, ever, ever, ever name minors as beneficiaries of any life insurance or retirement account. What will happen is that minor will not be able to take those funds until they're 18. They will be locked into a fund until they're 18 years old and able to access them. Absent that, we will need to go to probate court to get a guardian appointed over that minor's estate to get the funds. So in part, if that's the situation and they're minors, yes, we're gonna have to go to court. If it is a normal, just adult beneficiary receiving the funds, it depends. Because if anything is contested, if there's already a probate proceeding being opened and anything is contested in probate, you could potentially be looking at some litigation there.
Very good. Great question and great answer. Thank you, Yvette.
Yeah.
So here's a great one here. how do I identify a competent, uh, honest estate attorney?
Well, ask a lot of questions. But also know that we have to be in compliance with the State Bar of California, and any disciplinary actions that have ever been taken against us are also a matter of public record. So before you hire an attorney, do the homework, check them up, look them up on the State Bar of California, make sure they don't have any disciplinary actions, their license is good to go, they're actually practicing in the area that they're saying that they're practicing. And ask a lot of questions. I would err on the side of somebody that has not just started out with doing this work, that is maybe deeply involved with other bar associations or things like that. And at the end of the day, it should be somebody that you could have a relationship with. Like I said, this is a lot. We're in it for the long haul, right? Things need to get updated, and so if you don't see yourself working with that attorney past the signings, then that's probably not the best fit for you. You want to find someone that's a good fit for you and your family.
Mhm. Yeah, really great, Yvette. I will add a couple more things, and this is kind of part of our investor webinars that we do. I would say I would include number one, yeah, definitely doing your research, but also asking them if they would be willing to let you talk to their clients. Right? That it's you could get like a direct testimony from them, their clients, on the working relationships. Right? Everyone's kind of looking for something different, right? So yeah, oftentimes very qualified, very experienced, and very well liked attorneys, or especially estate planners, will have clients that will just provide glowing compliments and testimony. So
Yeah,
um,
I would just say caution on that though, because so we have to protect attorney-client privilege. We can't turn over like, oh, talk to my cousins or my client Susie, here's their number. But definitely go to the website, see if they have testimonials on there. But yeah, you're not, because you're not going to get a list of clients from an attorney. I mean, like we can't even say, yeah, that's my client or not.
right, all right, yeah,
We're a little bit different than other professions.
right. Good point. Thank you, Yvette.
Yeah.
Okay, so a couple more questions. We're coming up to the hour. I know some people are leaving. Just a reminder, this webinar is being recorded and we will publish it to our YouTube channel. I'm also sending a follow-up email, which will have a link to the webinar recording so you can watch it later on. I'm going to go a little bit over 1 o'clock just to answer a little couple more
Yeah,
questions
that's
here.
fine.
Let's see this one. Besides the home, what else needs to be put into a revocable trust? I know we had talked about that in that slide.
Yeah, so we did talk about it. It's anything that is an asset. So things that can be retitled are liquid assets, checking, savings, investment, brokerage accounts, things like that. Interest to LLCs or corporations or things like that. You would have to have the trust obtain the interest in that. That's not necessarily retitling. But the main one is always real property. That's the biggest one. Whether it's a rental property, whether that's the family home, it doesn't matter. That absolutely needs to be in there. And if you refinance, you take it out to refinance, you got to put it back in. A lot of people forget that. But yeah, again, I would say go back to your estate planning attorney, whoever helped you with it, and follow their instructions. I know my firm sends out a yearly schedule of assets just to make sure that my clients have that in front of them, fill it out, and that will generally trigger conversations about, I got this new asset. Do I need to retitle that? What do I do with it? So again, going back to whoever helped you draft it to keep everything updated.
Great. Here's another one. I created a trust in California, but I have property in Arizona. Do I need two separate trusts?
Um, so I'm assuming that this person lives in California and their property is uh in, where was it? Arizona? Yeah.
Yes.
So probate jurisdiction is going to go based on where you live and where you die. So the answer to that is no, but you do need to make sure that your out of state property is retitled to your trust, regardless of it being a California. If you move and you're planning to retire, and that might be a different conversation, but assuming jurisdiction is not changing and you're here, you would be able to just retitle that property.
Okay, great. It is 1 o'clock. I'm going to answer just, I'm going to ask a couple more questions
Okay.
here. Is California a state that allows a trust to remain open indefinitely after the person passes away? Um, can funds be distributed systematically over time rather than one large lump sum?
Yeah, so I think what that question is getting to is other states have this rule of perpetuities concept that comes in. California, for most people, if they're leaving it for their child and they want the child to have it, or their grandchildren to have it, that's not going to be a problem. Forget what the second question to that was.
Oh, I think you kind of answered it.
Okay.
The second part was talking about can money be distributed over time instead of,
Yes.
yeah.
Yeah, and that's the beauty of having subtrusts is, rather than having your 18-year-old inherit that life insurance when they're 18, having a trust set up for them so that they could take distributions according to what you say could be hugely important, right? So most 18-year-olds are going to blow it, but everybody knows their kids. But if have those bumper rail provisions where you can't get access to it till you're 25 or 30, I don't know, finish college, have saving, whatever that's important to you, you get a little bit more control over the final distributions.
Okay, and one more question. I know there was a number of questions that were emailed to us,
Hmm.
submitted to us during registration, and we didn't have time to get to those. But what I will say is we're going to work very hard to try to answer those offline.
Okay.
One of them that did stand out to me, and I'd like to ask because the DFPI were very well known for informing and creating awareness about frauds and scams. Is there
Yeah.
any kind of awareness or about estate planning frauds and scams? It's something of that nature that consumers should be aware of.
Yeah, no, that's a really good one. I see these all the time where there'll be billboard ads or street ads or whatever for like a trust for 199, and generally those are not being done by a lawyer that is licensed, that understands this area of law. What you're generally getting, and I've seen them, I fix a lot of one of these broken or scam plans, is they're getting a just boilerplate with just names changed, what is not specific to them, because these are not practitioners. They don't know how to devise specific language that needs to be included in them. So that's not, I don't know if that's qualifying as a scam, but in my book, that definitely is, because it's misleading. It's misleading people to think that they can pay, a little bit of money for a huge, big deal type of package that a licensed professional should and is only capable of doing, because we actually know the law in this area. So I would caution against that. If it looks too good to be true, probably is.
Yep, I agree, and that's what we
Yeah.
preach. That absolutely, everyone has different, very specific and nuanced financial situations and goals and assets, and you really do need that professional to look at your situation. Sometimes the template, especially people who are advertising things quick and easy, is not the answer. So, with that, I do want to do some fast, real quick housekeeping. So, as a reminder, we are having a student debt webinar happening this month on the 17th. It'll be at noon. You can register it with that link right there. Next month, we are having a Path to Home Ownership workshop, and that's October 2nd, right at noon. And you can register with that link right there. Again, a couple of different reminders. Please subscribe to our newsletter. Many of you probably got a reminder about this webinar through our newsletter. So if you're not subscribed, please click on that and get subscribed to us. This webinar is being recorded. It will be published to our YouTube channel, so you can always rewatch it. And again, if you want to provide any kind of feedback so we can make these webinars better for you, there's a link right there. Let us know how we can get better. With that, I want to say thank you. Special thank you to Yvette for being here, answering questions. Fantastic presentation. I apologize that we weren't able to get to all the questions that were submitted to us. They're so great, very complex. We will get to them offline. And with that, I want to say thank you. Have a great day. Please take care of yourself and each other. Bye.
Bye.